court judge that based on this, what do you think? We don't think there's anything we can do here. We cannot really prosecute. We cannot do anything. Although we arrested these people on suspicion of this thing, we were investigating to see the link on of their link to this crime. But as it stands right now, there's nothing we can do. What do you think, sir or ma? And they just said, based on that, we have to discharge these people. You don't have any evidence. Okay, because these people, part of the, what do you call it? Part of their right is right to fair and speedy hearing. Because they keep saying it, justice delayed is justice denied. Not just justice delayed for the victim. Yes, even justice delayed for the suspect. Because as a suspect, if you keep being a suspect for so long without any investigation concluding to pin you to the case, it's more like they're depriving you some certain degree of your right. So it could lead to justice delayed for you too. So why the victims of any crime, why they need justice, even the suspect, everybody involved, whether in commission, whether investigating, they also need justice on their own part, depending on their role in the situation. So the court said, you know what, you cannot keep seeing these people as suspects forever. Since there's nothing you have right now that you can charge them with, let them go. If tomorrow something comes up, good and fine for you. But as it stands now, you do not have anything to charge these guys for. They have to go. That is part of fairness in law. In the justice system, it is part of fairness. So based on that, they got the advice, and based on that advice, Sam Larry, Naira Marley, Prime Boy, whether Obele or Obebe or whoever, they were discharged by the magistrate courts. Baba Mohbad Igbomu only know that why would they discharge them? Because there's still a pending issue going on in the coroner's court. The coroner is investigating how Mohbad died, when he died, and circumstances leading to his death. That because that is going on, the DPP and the court cannot just release the suspects or discharge them, as it were. So, yes, we can read the updates. Let me grab my second phone. I can read the update, but I want to give people the background to the story so that, because by the time we start reading, I know there'll be a lot of semantics there that will throw some people off. So, by the time I lay some foundation to it, it will be easy for everybody and anybody to follow the story. So, based on that, Baba took case to court. They say, no, it will be miscarriage of justice if you're preempting the coroner's inquest by releasing people that they are not guilty or they are not involved in the death of this boy. That will be like you're preempting. It's like you're guiding the coroner inquest, like can you look somewhere else for your evidence or for your guilty fellows, if I thought they are guilty people here. So I think the court today, they now had the opportunity. It took the case to court, and you know our court system. They will file the application. They will they will depose to some oaths and things like that. And whoever they are bringing the case against, in this case, you call them respondents, because it's a criminal case and it's a private person against the state. So they are the respondent in this case here now. They will also file their own counter affidavit, counter application if they have, or any motion. They will do all that. They will continue doing all that. There will be some back and forth in the background. But today, was for listening to arguments. They had to come, they went to the court today, or maybe two or yesterday in some people's place now. Each side arguing their case that this is why I'm saying these people have no legal standing. These people, whatever they have done, is going to lead to injustice. And the state, they responded as the DPP. I think the police was part of, the police is also part of the respondent too. And I don't know who else. They will also make their own argument that, you know what, this man doesn't know what he's saying. This is how the case looks like and all that. So that's what happened in court today. And I think Channels TV was there to, or they had their reporter there to cover the event, and they wrote a story about it. And ẹ lọ jókòó, ẹ wá nǹkan jókòó lé kí n kà á fún yín. So where is this? So the Lagos High Court sitting in Ikeja fixed July 2, 2025 for its judgment in the application by the father of the late singer Mohbad, Mr. Joseph Aloba, seeking permission to quash the DPP's legal advice and court proceedings, which freed Naira Marley and Sam Larry on allegations of being involved in Mohbad's death. That is the heading. So, Justice Taiwo Olatokun fixed the dates after taking arguments for and against the application from counsel representing the applicant, Mr. Joseph Aloba, Senior Advocate of Nigeria, Wahab Shitu, and Joke Ametre, who represented the respondents. The applicant, Mr. Joseph Aloba, is suing for and on behalf of the Aloba family, while the Attorney General of Lagos State and the Director of Public Prosecution listed as the respondents. So those are the respondents, the Attorney General of Lagos State and the Director of Public Prosecution, that's DPP. So Senior Advocate Wahab Shitu cited a lack of fair hearing as one of the grounds for the application. So you bring an application to court, that will be like the basis, the foundation for the lawsuit. You're applying for something that we want this, whatever judgment they've gotten, we want it quashed. We want it rendered null and void. And you have to give reason that why are you quashing this? Why do you think this is wrong? And part of their reason is that there'll be lack of fair hearing. That's part of their reason. So in his application, Mr. Aloba had said the DPP's legal advice freeing the duo of Naira Marley and Sam Larry preempted the proceedings of the coroner's inquest, which is here to conclude its inquiry and sitting into the cause of death of the late Mohbad. He noted that vital suspects mentioned and implicated in the coroner's proceeding have been freed by the DPP's legal advice. That, so I'm trying to put a little bit of explanation here and there. So what Aloba is saying here is that advice they got from the magistrate court in Yaba, freeing Naira Marley and Sam Larry, that is preempting the coroner's inquest. More like saying, no, the coroner inquest is not going to find them guilty anyway. Why not just free them now? So and they are now saying people implicated, according to Joseph Aloba and his lawyer, that Sam Larry and Naira Marley, that according to them, they're saying they have been implicated in the proceeding of the coroner's inquest, that they are vital suspects, and that the DPP's legal advice has decided to free them. So, continuation. In their counter affidavits, that's the respondent now, filed June 24. A legal assistant in the office of the DPP, Uday Ibrahim, deposed that contrary to the admission of Mohbad's father, the suspects who were released by legal advice were not acquitted but discharged. So while we are going on, or if you have the time, you can quickly check the difference between being discharged and being acquitted in the court of law. Also, the difference between being discharged and acquitted as against the other two. Let's continue. The deponent, that's the lawyer from the, what's it called now? The lawyer from the DPP. That's who they mean by the deponent here. The deponent said he was informed of the facts of the case by one Mr. Akinde Oluwaseun, a chief state counsel in the Directorate of Public Prosecution, which facts he believed. Because this guy, the lawyer, the Ayinde Ibrahim, is one of the lawyers in the DPP. So he needs to, whatever he's deposing to, it's like swearing an oath there. So he's saying this is where he got this information from, and he believed that person. That person happened to be somebody who is senior to him in the office, like a guy to who in charge of his share. They now explain the facts of the case to him that this is what happened here. Don't mind these people. This is what actually happened. Basically, they gave him the case file. So, and he believed it. So, in the document, Ibrahim, that's the lawyer in DPP, Ibrahim stated that the respondents, that the respondents now, don't forget, is the Attorney General and the Director of DPP himself. So the respondent admits paragraph 8 of the affidavit in support of the motion, only to the extent that its officers participated in the hearing of the inquest into the death of the late Oladimeji Aloba, and also to the extent that upon conclusion of investigation by the police investigators into the death of the deceased, the investigators forwarded a duplicate case file to the office of the second respondent, that's DPP, for the purpose of review and issuance of legal advice. So what this paragraph is saying is that there are some affidavits that, what's it called? Joseph Aloba gave. When you bring in this, your application, you want to start a lawsuit and things like that, you will make some affirmation. So you call it affidavit, like, this is what I know about this. I know this has happened. I know this has happened. I know this has happened. Based on that, why I'm asking for this. And you will swear that this what you're saying, to the best of your knowledge and recollection, that is the truth. If anything is found to impeach whatever you have said there, then you can be sued or you can be charged for perjury, for lying under oath. So, what that paragraph is now saying that in Joseph Aloba's affidavit, there are different paragraphs there. That in the paragraph 8, that they agree with some of the things that was said there, and they mentioned what they agreed there because a whole lot of things was said in the paragraph 8. And the things they agree with there is that, yeah, so we participated in the hearing into the inquest into the death of Mohbad. Yes, we participated as one of the authorities there. And when the police also concluded their investigation, the police forwarded a duplicate file to us. And the purpose of that is for us to review whatever the police did with that. Because in a way, they are like an oversight function. They are like people who review the work of the police officers. Okay, you've done this, you've done this. Are these things lawful? Can we take it to court and get anything out of it? So they send the duplicate file to DPP for legal advice and for review. And they agree that, yes, we know about this one's true. So, the next paragraph. Contrary to the deposition in paragraph 4, and generally in the applicant's affidavits, the suspects who were released by the second respondents, by the second respondent's legal advice, were not acquitted, but only discharged. It's reaffirming that here that these people, they were not acquitted though. Now only discharged, they discharged them. Oh. So the respondents deny the deposition in paragraph 7 of the applicant's affidavit. So basically, what they're doing as part of the argument in court is that putting hole in whatever Joseph Aloba said, now him bring case come that this and this and this and this are what he believes in. So the job of the opposition, in this case, the Attorney General of Lagos State and the Director of Public Prosecution, their job then is to put holes in that story. Now, you said here in paragraph 1, no, this is how it should look like. That is their job. If they are able to successfully puncture their story, then there won't be any case. That is the point of all this back and forth. So the respondent now is now denying, it denies the deposition in paragraph 7 of the applicant's affidavit in support, as the presiding coroner is here to pronounce a verdict which implicates the release or suspect. So this 1 year is heavy, if only you understand what is there. So he's now putting it back because the basis, one of the basis of the case of Joseph Aloba here, I'm not really looking at comment section, so if there's something I really need to attend to there, somebody might have to unmute and let me know. But let me just finish the reading, and I know I'm doing too much of explanation in the middle, but let me just land. So what that paragraph is saying is that Joseph Aloba's one of the foundation of his case is that the coroner, some people have been implicated in the coroner's proceeding. If you were following my reading, it was maybe in the second or third paragraph that I read that why would the legal advice release these people when they have been implicated in whatever was going on in the coroner inquest. Now, the DPP and the Attorney General, they're now putting it back to him that the coroner magistrate has not, whoever is presiding over, has not pronounced any verdict that these people we have released or they are implicated. Now, why are you now implicating them by your own words? Why are we going to keep them suspect forever when up until this moment they have not been implicated? The coroner judge have not pronounced that this person hold them title, say this person and then do this thing, that on what basis should we now continue to label them as suspects? That is essentially what that paragraph is saying. So while asking the court to dismiss Mr. Mohbad's application, not Mr. Mohbad, here is Mr. Aloba, Mohbad the local application. So while asking the court to dismiss I'm going to replace the Mohbad with Aloba, Mr. Aloba's application in the interest of justice, the respondents traced the process of obtaining the DPP's legal advice, the role of the DPP, the kind of information, notably the criminal case file, which the DPP, and neither the coroner nor the applicant had access to, concluded that there was no fact disclosed which linked Naira Marley, Sam Larry, Prime Boy, and Okpere Babatunde directly or remotely to the death of Mohbad, a situation which formed the basis of the DPP's advice, freeing them. Yes, I know this one is loaded, this paragraph. So what this paragraph is saying is that the lawyer is saying why the DPP got this legal advice, why they went to court for this legal advice. that is because of the case file, the criminal case file, that the police, the investigating officers forwarded to them. They are now pointing to it that the DPP, they have this case file. They are now saying the coroner inquest or the applicant, that Joseph Aloba and his lawyer, that they do not have access to this file. That why, how, or on earth, or based on what we they say, whatever they have done, some people have investigated this issue. Authorities have investigated this issue. They have forwarded their case file to us. You don't have it. Even the coroner magistrate, it doesn't have the what's it called, the case file, and that it was a case file they based their legal advice on to freeing these people, discharging them. That is the basis. There is not like they have any other special interest. That they're only working with the facts available to them. Basically, that's what they are saying there. So he said that's still the lawyer arguing. Contrary to the deposition in paragraph 8, now they have moved to paragraph 8 of the applicant's affidavit. That's Joseph Aloba's affidavit. They said Oluwaseun Akinde Esquire, from his experience as co-counsel, knows as a fact that the police is bound to send the duplicate case file to the respondent in any case file in which a prima facie case of an offense triable by information is disclosed, such as the one under reference is disclosed. So he's now saying that on Joseph Aloba's affidavit, I don't know if I can get the affidavit somehow, but I don't think it's available online or anywhere. So basically, from I can infer from whatever has been said in this paragraph now that in Joseph Aloba's affidavit, a paragraph there, paragraph 8, is saying that why is the case file forwarded to the DPP and the Attorney General. So it's now putting it to them that it is a non-fact that the police is bound. Bound there means bound by law. They have the obligation to send the duplicate case file. Yes, maybe not the case file itself. The original case file will still be with the police, but they have to duplicate whatever, the document, everything they've done, duplicate it, send it to the DPP. It is the law, especially when they have prima facie case that on the surface, that's the big word, the prima facie is not just on the surface. If you feel, if the facts can speak for themselves, if you, for example, you're going and you see somebody with a knife stabbing another person, the case itself has its own merits, and the merit is that you were witness stabbing this man. If this man dies, we can really hold you for it. So there is a merit. The case itself has its own merit. You don't need to start any detailed investigation. So that's the meaning of the word prima facie there. That's so the police is bound. When things like this happen, they are bound by law to send the duplicate case file to the DPP. So it's still part of putting holes in Joseph Aloba's affidavit. Let's continue. So, further to the above, the respondent states that at no time did the presiding coroner looking into the death of the deceased issue any directives that mandated the respondent to inform it of the conclusion of the second respondent's review of the duplicate case file, which is the conclusion captured in the legal advice sought to be quashed by the applicant. So here is saying that we are doing this and we have done this, and at no point did the coroner inquest issued us any mandate or any directive that, you know what, I want to see your file after you review it before you go and do anything on it. That if there is no law, if there is no authority asking them to do this, why should they go out of their way to do things they are not required to do by law? If the law is saying this is how you do this thing, they have a process, they have a procedure. Why should we go outside of that procedure? So what they are saying that if the coroner inquest had told them that, you know what, if you finish reviewing this thing, send that, we want to see that file. We want to use it for this case we are doing. Then they would be bound by law to send before they go to the court to ask for legal advice. That is what that paragraph is saying. So it's still like they are arguing their case that these people don't know what they are doing. These are things should look like. So the second respondent, which is the DPP, was not instructed to halt his mandatory statutory review of the case file, nor ordered by the first respondent, which is the Attorney General, or the presiding coroner, or the chief coroner for Lagos State, to inform the honorable presiding coroner whenever it was ready to issue the legal advice. Saying at no point, that's what I'm trying to explain that to now, that DPP did not get any instruction, any ceasefire, any directive from whether the Attorney General knew, or from the Chief Coroner of Lagos State knew, or from the judge presiding over the issue of the issue of the coroner inquest, that they didn't get any directive from them that they should stop what they have been mandated by law to do. Because yes, even if the law gives you a power to do something, the law still puts some power in some people's hand to tell you, yeah, stop, don't do that thing. They are now saying, if the law has asked us to do something, nobody is telling us not to do it. No other authority is telling us not to do it. Why should we now halt? Why should we stop doing what we should do? Why should we stop our mandatory, our statutory obligation, our statutory duty? So they are saying they are acting in the bounds of the law. That why should they stop? That even when they have that, why should they come to tell the coroner that, oh, we are ready for legal advice now? If nobody is telling them this is what you have to do, they have their procedure backed by their laws. Anything that will stop them from going that way would be another instruction coming from an higher authority. So the police, in addition, the respondent states that it was the police investigators who, for the purpose of remand proceeding, pending their conclusion of investigation, presented the suspects before His Honor, Mrs. A.O. Olatubosun, who subsequently remanded them while awaiting the legal advice of the Directorate of Public Prosecution, the DPP advice. Let me read one more paragraph before I explain that. The police investigators were not instructed by His Honor, Mrs. A.O. Olatubosun, or the first respondent, that's the Attorney General, nor were the investigators under any statutory duty as part of the investigation to inform the presiding coroner that it was forwarding or had forwarded the duplicate case file to the office of the respondent. So, the police investigators and the respondents working on a prima facie criminal inference of the death of the deceased were independent of the presiding coroner. Good. So what those three paragraphs or four that I just read, what they're saying is that the police investigator, when this issue started and they started their investigation, because they had to hold Naira Marley, Sam Larry, and the rest. They had to hold them for more than 24, 48 hours as required by law before presenting a suspect, charging them with an offense, and presenting them in the court to have their own fair hearing. They had to go to the judge, this judge Olatubosun, who eventually gave the DPP legal advice that they approached this judge that yes, these people, it looks like we're going to be holding them for more than 24 hours because we are still investigating this case. They had to apply for a remand order that we want to remand this, we want to keep them with us for now. We need something to back us up because the law is saying we cannot keep them for more than 48 hours. So the judge granted them the remand application that you know what, so you go and keep them and continue your investigation. So it's now saying it's still the same before this judge that they presented these people back that while you're waiting legal advice, keep these people. But then, as part of the internal rule of the police and their procedure too, they have the power to grant administrative bail too. Yes, the court has given them the power that keep these people in your hand. If those people, while doing the investigation, if they feel okay, you can go home for that, but you have to report here every Monday, every Tuesday, the law has given the police that power to grant administrative bail. Because somebody might be asking, if the court is asking them to remand these people, how come these people got released somehow, somewhere? The police has that power to grant administrative bail to people in their custody. They just need some, oh yeah, bring your passport, bring this, bring that. That's what they need. So the second paragraph there is now saying that these investigators that we're talking about, the judge did not give them any instruction. That's the judge, they got the remand instruction from them. He didn't give them any instruction. The first respondent, which is Attorney General, did not give the police any instruction because the Attorney General has the power to give them instruction too. Or they now say even the investigator, that's the police, they are not under any law, any statutory duty that part of your investigation, no, you must go and inform the coroner presiding judge before forwarding your case file to the DPP. It is not part of their job. No law is compelling them to do that. And nobody has told them, you know what, this is what you need to do. Meaning that the police needs to go about their normal way of doing things. And their normal way of doing things is that after concluding their investigation, they forward their case file to the DPP for review and for legal advice. So it's now concluding that based on all this, the DPP and the police investigators and the Attorney General of the Federal of Lagos State, because they are working on a case based on the merit on its own, not really based on one deep inquiry or investigation, based on the merit on what they are seeing at first hand, that they are independent of the presiding judge, the presiding coroner. You can call them coroner, you can call them judge because they are judge before they are coroners too anyway. So that they are independent of that woman or the man, meaning they can do their own thing, they can run their own show while he or she is running her own show there. So the next paragraph, the respondents are answerable only to the presiding magistrate who ordered the remand pending the issuance and of whom the legal advice was forwarded when it was issued. That because of all this, Attorney General, DPP, even investigators, they are only responsible, only answerable to that judge who told them that, oh yeah, go and keep these people for now. That is the only person that can now tell them, let me see what you have done with this. Not the judge who doesn't know how the remand, how it came about. So the thrust of the intervention of the presiding coroner into the death of the late Ilerioluwa Oladimeji Aloba, is different from the statutory duty of the respondent as pertain to the police case file. So they are saying that everybody gets their own duty. The coroner, in they do his own, is doing his own. We have our own statutory obligation. What we need to do based on the facts we have, that these are two different things that should not be mixed up. While they're explaining that place again, while the presiding coroner's mandate is to determine who is the deceased, when the deceased died, where the deceased died, and how the deceased died. The mandate of the respondents, by now you should know who the respondents are, the Attorney General and the DPP. The mandate of the respondents, particularly the second respondent as the DPP, is to determine if there were any prima facie criminal inference disclosed against any of the suspects in the duplicate case file forwarded to them. Let's break that down now. So they're saying the job of the coroner inquest is to determine who died, the person will die, how he take die, when he take die, where he take die. That's who, when, where, and those are the four questions the coroner's inquest is supposed to answer. Who died, when the disease died, where did he die, and that outside that, the coroner's inquest will be acting ultra vires. That, in contrast, the job of the respondent, the Attorney General of the Federation, and especially the DPP, their own job is to determine if there's any merit, if there's anything they can infer, they can draw from the investigation from the case file forwarded to them by the police. So they are not supposed to go outside the case file forwarded to them. They are not the investigators. They're just there to prosecute based on the file forwarded to them. You see that they prosecute or they decline to prosecute that. You know what? I don't think we can get more evidence. Guys, go and get us more evidence, then we'll continue. Mhm. So, based on that, this man here is now trying to say, you know what? This is the job of this guy. This is our own job. So, the respondent vehemently denies paragraph 10, 11, 12, 13, 14, and 15 of the affidavit in support of the motion, and states that the averment therein exists only in the realm of imagination of the applicant, and thereby put him to the strictest proof of the allegation. So I don't have the affidavit. I would have loved to read that too. And DPP, they are now saying no, we no go agree. Say waiting there for these paragraphs there. Say na lie. That everything where they talk for that paragraph, I don't know why we don't have that the affidavit. If Josie get mine, Josie, if you have the mind, release the affidavit. Let's see what you have there. Let's see the lies you've concocted there. So basically, you can, from the words here vehemently, you know, say the lawyer no agree, the para say no, say which kind talk beyond this one. Say all these things where
Mr.
did this
Pythagoras
paragraph.
ẹ má bínú ṣé bó ṣe kọ́ lẹ́sẹ̀ edition.
Say all these things where this man talk for this paragraph, oh, say the man just the imagine things. So say all these things can only exist in the realm of imagination. Say you just sit down for us with the look silly. Say, I will say now maybe King of England. I will say that I will be president for one Obodo Igbo country. Say all these things can only exist when you have that quiet time in the toilet and you feel you are the owner of the whole world. So that's basically what this man is saying here. That and because of that, oh, they need to prove whatever they have said there. That if you decide that you can sit in the corner of your house and decide what happens in the rest of the world, then you need to bring some proof to all these allegations you have made. Because they've made a whole lot of allegations there. I know say they don't call Attorney General and the DPP, they don't call them different names. They don't abuse their mama, abuse their papa. Now why the lawyer vex like that? Say no. Say the only thing we feel happen, you say this man just they imagine. You don't want to tell and say whether the man they mara or something. So to the next paragraph. The respondents state further that neither the coroner nor the applicant have access to the criminal case file to ascertain and appreciate the legal basis that form the conclusion reached by the respondents in the legal advice. So they are now saying that I think they've said it somewhere in the earlier paragraphs that these people where they talk, they don't even get the case file for hand. How they want to appreciate what we do? How they want to understand what they there? Though the the corona judge, no contest here. They just they join the guy for the matter. Say male and two collect together, and then they give aloba. Then they throw one give the woman there too. Say, and I not get case file for hand. You don't know waiting happen. You don't know waiting these people right there. What if the police say they are based on our investigation? No, these people we don't see them at all. No, they don't do anything at all. We don't see any facts say they do anything. So shame DPP because of that. Go and say, no, they do something. No, they investigate. Do they have investigatory power? No, they have prosecutory power. They can only prosecute based on investigation done by the police. So they're saying these people don't get case file for hand. Then they hear the followers argue, say, now so this all matter supposed be. Say, which can we allow this? That's what we have in that paragraph. They can't appreciate, they can't understand basically their own legal basis of saying or doing whatever they have done. So the applicant did not personally conduct any or engage private investigators who investigated and found incriminating evidence that establishes the culpability of any of the individuals discharged by the DPP's legal advice for the death of his son. So they don't Joseph Aloba for blockers here now say, you know, pay any private investigator, you know, engage anyone, maybe apart from Yomi. That I think Joseph Aloba made a mistake here. If he had included Yomi in this one now, if you say, Yomi, that my private investigator. So they say you didn't conduct any investigation of your own. You did not hire or engage any private investigator to investigate all these things you're saying, all these evidences you're coming here to say. You didn't get anybody to investigate for you. And you just call your conde yarn up at say, now one person kill your picking, now another person kill your picking. So they're just really telling that this man is irresponsible. This man just opens his mouth and things start coming out. That's basically what that paragraph is saying. So, upon a total legal review of the case filed by the second respondent, that's DPP, there was no fact disclosed that linked Mr. Abdulaziz Fashola, aka Naira Marley, Mr. Samson Balogun Eletu, aka Sam Larry, and Owoduni Ibrahim, aka Prime Boy, and Okwere Babatunde directly or remotely to the death, to and for the death of the deceased. They are now saying case file wey una no get, wey na because of that they talk anyhow. Oya, make we come tell you now. Based on the case file wey dey our own hand, we don review am. We don do holistic review to this case file. And in that case file, any fact no dey there wey link these guys dem, whether na directly abi remotely say na them cause the death or na them kpai this boy. Say based on the case file wey dey their hand, say no fact dey inside. So they are not saying there might not be facts later on. They are not saying this thing didn't happen. They're only saying based on what we have seen in the case file, there is not one single fact there linking these guys to this thing. What should we do? Should we just keep holding them forever? So moving on. The applicant and the other individuals who testified the inquest hearing into the death of the deceased did not provide any new, credible, and verifiable facts distinct from what was stated in the case file forwarded by the police investigators to the second respondent, which directly or remotely linked Mr. Fashola, Naramali, all those guys to the death of the late Ilerioluwa Oladimeji Aloba. So they are now saying, yes, even with the inquest where they go on, then they hear waiting they go on there too, because they have their own representative in the hearing too. That up till now, nothing new where these people they talk. Because don't forget, all these people they wrote down their statements to the police. And anytime they come to the coroner's inquest to be interviewed or cross-examined, their lawyers will ask them, oh, do you remember this thing you've written down? Do you want to adopt it as your testimony here? All of them are saying yes, that is what they're saying. Meaning, that is what their facts are. And they are saying all these facts were in the case file. That's all waiting new where they can talk here. They're not talk anything new. They're not talk anything where they feel verify. Say even something where they knew there. Say it is either it is not credible or they cannot verify those facts. So they are saying two things here that number one, nothing is new. And number two, the things new or whatever new they have said here is not credible. It's not verifiable. So what they're saying basically again to break it down further is that anybody saying that this one kill this one, that this one kill this one here in the coroner inquest, that person is either not credible or the person they lie. That is basically what that paragraph is saying. So, and I think this is last paragraph. Thank you for bearing with me. The applicants in these applications have not placed any material facts other than speculative statements and conjectures, such that could have faulted the second respondent's legal advice. And it is in the interest of justice to dismiss this application against the respondents. So it's now saying Joseph Aloba, this lawyer, they don't get any fact proof you say this one fact or this one the main. Say the only thing where they get na speculation. Say it be like say something can happen. It can't be like say after that one something can happen. Say that's what they came with. They didn't come with any facts other than speculations, other than maybe it could be, it could have been. That's all they've been saying in the affidavit and in their case generally. Now, they didn't bring any fact to fault DPP's legal advice. Okay, now don't go collect legal advice. So see as in our legal advice take wrong. This person will not release. See waiting, see the fact where they on ground. See the video where we see the person, they kill person. Why not can't release them? Something like that. Something tangible. that in the interest of justice, because justice is not just about wasting people's time, wasting the taxpayers' money. Justice is about saving time when hearing cases, saving money for the taxpayers, and delivering justice. And in the interest of all this, I beg, make una try dismiss this application. And because say, okay, no wala, may na come back on July 2nd. We will talk more about it and we'll see how to resolve this issue. So, abomilele you. Now, if
Welcome,
we have
ẹ káàbọ̀ sà.
questions and we can now talk about it. Ekule Yami.
Ó wà pé tájò rẹ̀ àwọn wá sókè jẹ́ ẹ̀kọ́ ó lọ jábọ́ bí wọ́n máa padà níta Pythagoras bọ gbogbo nǹkan tẹ́ sọ yìí.
Yes,
Ṣé mo lè
Chabby,
sọ̀rọ̀ sí
tell me.
nítorí mi mọ̀ bóyá fẹ́ sọ̀rọ̀ lẹ́yìn ìgbà tó pàtó tẹ̀. So
Yeah.
gbogbo nǹkan tẹ́ sọ sí okay tájò rẹ̀ ẹ go on.
So, good evening, everybody. I just have two questions. Thank you so much, Mr. Pythagoras.
Yes, ma'am.
So, the first question is, um, as a son, I feel like he should have done his due diligence before going to file that kind of motion, right? So I really don't understand why, because for me, I think the charges has to be charges filed have to be appropriate. It's just like, for example, tí èèyàn bá unintentionally pa èèyàn, right? Unintentionally, you cannot charge that person as in pé it should be like, let's say, manslaughter and all that. But if the charges is not appropriately filed, there is tendency for that motion to be discarded, right?
Yes.
So in this case, I was just wondering, pé as a son, even like a junior lawyer shouldn't have made this this kind, I mean, it's not a mistake. I think he was just trying to do his job, just trying to kind of thinking he's working. I mean, he's working for the money, just to justify the money, right? And the
Mm.
other question is, does the respondent, which is the DPP and the Attorney General in this case, do they have to record? Do they have to seek permission from the coroner inquest to make public their review or their judgment on the case, to see if the case can go forward or not? Do they always have to?
Yeah, sure. Uh, yes, number one, the lawyer, to be fair, as long as you decide to be someone's lawyer, you have to act in their best interest and based on their instructions. As
Based
long
on whose
as you want
instruction? Based on your
your
client's instruction?
clients, yeah. As long as you remain their lawyer.
Even though you know it is wrong or it's not going to be
No, if it is
admissible.
wrong in terms of law, except it is illegal, the only instruction you
Uh,
won't listen to from your client will be something against the law. To lie under oath, for example, to help them pervert justice, for example, knowingly. Those kind of things, you can say no to it and you can even report to your client to it for it. But anything other than that, it's either you stop being their lawyer or you dance to their tune. Really. That's just
okay.
it's more complicated than that, but that's just a simple explanation. It's either you just
All right.
say, Baba, I know they do again, or you just continue doing their wish.
Oh,
Uh,
okay. Okay.
yeah. So it's but then if you practice to some extent, to some point, and uh your what's the word there now? Your image means so much to you, your integrity. You have that. There are some things that you stand your ground. You have the power to advise your client to convince them. And when you can do that, you have the option to say, you know what, I cannot do this in good conscience.
Oh,
But
okay.
then it's all about what you really want still. If I want money and somebody is telling me to come and kí wá lọ bá òun gba kí wá lọ bá òun sùn Charles pé òun ló yẹ kí tróònù kàn tó dẹ̀ jẹ́ pé ọmọ kí ló ti ń pè ọmọ ayédè ni níbì kan bá lọ máa sún ẹ̀ tó bá ti kówó ẹ̀ sílẹ̀ ń pé òun ni tróònù kan tó bá a máa fọ́ọ̀mù story pé yes nígbà tí queen ni bóyá first àbí first queen ni wá ìgbà yẹn ni ó wá lóyún ẹ̀ Nàìjíríà bàbá ẹ̀dùn create a story conjecture báwa lọ bá ṣe bọ́yẹn ń kó story jọ bọ́yẹn ń kó gbogbo assumptions àti conjectures jọ yìí a máa kójọ náà eventually tó bá jẹ́ pé ẹni tó ń wá owó tí ò kọ̀ láti ṣe anything láti wá owó of course they can do it within the ambit of the law even though it might be morally wrong they will still do it and they will still be doing their job still really they'll be doing their job. So for the second question, you're saying that yes, the DPP do not need their what's it called? Their permission. In fact, the DPP has the constitutional authority as per the law establishing them to either decide to continue to advise on whether or not to prosecute a case, to discontinue or not to discontinue a criminal proceeding. They have the authority. The Constitution grants them that authority. The 1999 Constitution grants them the authority to prosecute or to decide, you know what, we are not prosecuting. Except where there is clear abuse of power. There's even a legal precedent backing it by the Supreme Court, stating that DPP cell, they get the power. If they say they won't do, they go do. If they say they not do, nobody feel owe them. So that one is clear. And that is part of what these guys are trying to affirm here, that this might just they waste people time, that we have the power to decide if we want to prosecute or not. Nobody can force us to do it. So I can tell you for a fact without preempting the sitting of the court, that no court can force the Rivoya go prosecute. If they say they don't get fact to prosecute, say that the court won't go, make the court go prosecute now. So nobody can force them to do it. They have the authority, except where there is clear abuse of power.
Okay. Okay.
Yeah.
Okay. So the DPP determines the legality of any case brought before the.
Based on the facts presented to them by the investigating authorities.
Oh, okay. Okay, that makes sense.
Yeah.
Thank you so much. Appreciate it.
You're welcome, man. I'm sure pé visitor ti máa sùn lọ́n tiwọn.
wọ́n ti sùn kánà ti sùn ni wọ́n ti máa interject rẹ̀ ṣe ń sọ̀rọ̀ question mi náà ni question mi náà ni part of my question náà ni Tádérọ̀yà ti bẹ̀rẹ̀ lọ́ ti bẹ̀rẹ̀ yẹn pé ṣé Sanchito lè sọ fún pé jossy nonsense ni kọ́tà fẹ́jọ fáwọn but hey he was hired, he was paid, so he has to do his job. So I guess that is what
tí ò bá ṣe kó dówó lówó padà.
owó tí ìdí ti jẹ so I guess that is just what is there, because even with all this I just think San should be thinking about it like, hey, this is like a slap on his face. pé on a good day this shouldn't be where ibi tó ti máa find ààrẹ. But hey, he has to that. And I think Josie is doing it for the purpose of mo try mo gbìyànjú láti wá justice for mi ṣùgbọ́n fọ́ọ̀mù ẹ̀ dárí but it's so kìíní fóun. So I think that because Vayo was there ranting this morning about gbogbo jati and looking at it, even though èmi tí mi kì í ṣe lawyer gan, it's so it's so clear right then. Pay what is it that you are fighting for? You are fighting based on nonsense and rubbish. Ló ń
So,
jalè lórí. So
kí tó continue,
ó yẹ go
I just had to answer. Who was that again? Bonnie, Abina. Somebody was saying, yeah, princess. Yes, I was saying you should go check it out the other time. It's simple. Yeah, they might look confusing. Discharge is leave this guy, made it go. You don't have anything to hold him for now. I beg, let him go. Acquitted is that the case has been tried. We don't follow this guy, drag matter on top this crime. But we no see hand there. You are now acquitted. It is a final judgment. Acquittal is a final judgment. It's either that doesn't mean it can be appealed. For example, if an high court acquits you, somebody else can appeal that decision in the appeal court and even take it to Supreme Court, depending on the case. But for that court, for that level, acquittal is the final decision of the judge. It's a final judgment there. It means legally you have been cleared of the charges that was brought against you. It means you are not guilty after you have been tried. Means you have been tried, you have been tested, and you have not been found wanting. As opposed to discharge. Discharge is just more like a temporary stop. Like, you know what? We don't get anything to hold this guy, but we they carry one eye, they look at somehow. The person can still be arrested, they can still be tried. As soon as new evidence comes in, they can hey, God don't catch you. We don't catch you for another one, so now you be this. So that is the major difference. But for the acquitter, it means for that crime, nobody can try you again. If you even if now you do harm and you are acquitted of the crime, of the charges, may them go look for another charge, can't charge you. That one don't go be that. So, but in this case of these people, they were discharged, not acquitted. Meaning they were released because at the moment, as we stand now, there is no fact, there's no evidence to tie them to it. Should we stop them from their own lives? Yes. No. I mean, should we stop them from their own life? We cannot. Yes, we are. It looks somehow we are paying like, job and people you should by. These are the things we know. But it's not about things you know. It's about the things you can prove in court.
it's about the facts and the evidence that you can bring out from it.
Yeah. You have to prove it that, yes, you might know A happened. How can you link A to whatever we're talking about here? How can you prove that A happened? Yes. But then you prove it. Ìbọn tó fi padà, màá ríbọn yẹn mọ́ o. Mo kàn dẹ̀ jọ pé mo ríbọn yẹn fìrí ni o. The case is going here. Case yẹn ń bọ́ lọ nìyẹn. Níbo ló ti rí tó ti pa? Mo wà ní báńkólì ni, mo rí tó pa ń sàlẹ̀. Later on find out pé o jẹ́ èèyàn kan tó máa ń lògò lògò láàárọ̀ ọjọ́ yẹn nígbà tó wà bá kó ní ẹ̀ wọ́n á jẹ́ kàn pé báwo lè rí nǹkan tó ṣẹlẹ̀ ń ta mẹ́ẹ̀ on a good day o máa ń lògò láti rí nǹkan dáadáa kéèsì tí ń lọ down the drain yẹn.
With what you said, there was a case like that lóòótọ́ tí woman yẹn that it was a murder case níbí báyìí ni and kí lorúkọ ẹ̀ bíi neighbor yẹn kó wá sọ pé àwọn òun rí nǹkan tó ṣẹlẹ̀ níjọ́ yẹn gangan and they almost believe this woman until when somebody said pé obìnrin yìí máa ń lògò and they now asked her, did you use your glasses? Ó ní no, ó lóun ó ní but image tóun rí. So you saw an image, not that pé ẹni yẹn gangan ni. So yeah, there was a case
you have
like
to
that.
prove it, otherwise
Yeah.
why the burden of proof, especially for criminal issues on the high side, is because even if it's a 0.0009% that an innocent person might go to prison for something they didn't do, we have to prevent it. That's why the burden of proof is high when it comes to criminal issues. You have to really prove it that any ló ṣe kíní sẹ àwọn nǹkan tó dẹ̀ fi ṣe lélẹ́yìí. This is how it happened. Because tá bá leave ẹ̀ open bẹ́ẹ̀ yẹn tí wọ́n leave ẹ̀ relaxed, it's easy for ọlọ́pàá láti wà lazy about it that ìwèrè yẹn oníjàgídíjàgan ni ló máa pa bọ́ọ̀ yẹn jàre ó yẹ lọ tì mọ́lé. Ó kọ̀ dẹ̀ lẹ̀kọ̀ jẹ́ oníjàgídíjàgan kó má jẹ́ ẹni tó ń pààyàn. Èèyàn mélòó náà láti máa tì mọ́lé fún nǹkan tí wọ́n ṣe. That's why
True.
the
Very
burden of
true.
proof is very important.
It's very sacrosanct. Yeah. Yeah. Totally so. Totally so. Then what's the question? Because mo fẹ́ bèrè lọ́wọ́ yín nǹkan bọ̀. Wọ́n ti gbàgbé. I forgot that
Yeah,
question.
so
Just pa mi lórí.
Josie just what they're doing is just more like an academic exercise. Was Prime Boy discharged because there was no one that witnessed the fight? Yes, they are not. The charges, number one, is not about the fight. The charges is about the death of Mohbad, not the fight with Mohbad. So that's the case before DPP. Because case file tó gbé lọ síwájú on investigation into the death of Mohbad pé these people wọ́n ní nǹkan ṣe nínú ikú tó pa Mohbad. Yes, it will be in the case file tí pé ó bàjà, but where do you link it in pé ìjà yẹn ló fa kú? The link is not there in the case file.
And
The
also,
DPP are saying, yes, ma.
Mr. Pythagoras, and also in Prime Boy's case, almost gbogbo àwọn tó give testimony in the court ló ń sọ pé kò hit ẹ̀ back. Tó bá yẹ pé òun ló hit ẹ̀ back tó fi ní wound yẹn, probably it would have been easy to talk about. But everybody was saying òun fúnra ara ẹ̀ ló fọwọ́ ẹ̀. Fine, it triggered him to do that. But òun kọ́ ló ṣe. It's not as if
Exactly.
òun ló ṣe.
Exactly. So it's more like even ọmọ tó jẹ́ tiwa, they couldn't do, they didn't witness it. Ọmọ mi didn't witness the
Yeah.
fight. Adra didn't witness the fight. So they can't really say anything like 100% pé àló bàjà sẹ́, àló lù sẹ́, àló ṣe báyìí. They couldn't say it. So based on what ni kí DPP, until tó bá ṣe bẹ̀rẹ̀ sí ní fọ̀rọ̀ wara wọn lẹ́nu wò, tí corona bá wá rí àṣírí yẹn mú jáde pé wèrè yìí lù lóòótọ́, ó ṣe nǹkan báyìí lóòótọ́, then they can now continue. And that's why I sọ pé all that happened is what he was discharged. He was not acquitted. Meaning, if we now come out with new evidence, pé ọmọ ń pa ẹ̀, àbọ̀ ṣe kínní sẹ̀, wọ́n á lọ pè ọ́ padà pé yá lágbájá stop gàrí tó mú yẹn, wọ́n á lọ mú yòókù lẹ́wọ̀n.
Yeah, likewise, Mr. Pythagoras. And this, I know, so a lot of people have different opinion based on this. When you look at the Sam Larry and Naira Marley's case, one, him even going to the DPP and telling them that why would they let them go? One, they were not charged for the death of Mohbad. They were that was the reason for their arrest, right? And because of the investigation, they found out nothing. Because even me looking at it with this eyes, with Oju, me looking at it, gone. One, apart from where they were not in the country, there is nothing for now that links them to that death. To me, my own opinion and my own thing, why I'm standing against these two guys was because of the bullying. So I think that is where, I don't know why even with that, Sanshito cannot even let Josie know pé kò sí nǹkankan tó link àwọn people ìmọ̀ ikú ọmọ ẹ̀. But when you're talking about the bullying, torí ó dàbí pé, and that is part of the nonsense they tell pé gbogbo wọn fi kún lórí TikTok àbí It was based on the bullying. There is no way we could attach them or join them to pay. Okay, hello, and you don't go let boy or hello, nínú oko, but we can see the bully. There is paper trail of petition that Mohbad wrote. So it's based on that. I don't know why they are attaching the death of Mohbad to these guys.
Yeah, so and for people asking why are they just suing them for bullying, it's neither here nor there because they might not have a sufficient evidence to successfully bring a case, a civil case of bullying. But if you're talking about a criminal case of bullying, it's not in Josie's place or his lawyer's place to charge Sam Larry for that. It will be the police if the police have sufficient evidence. Although they told us from their preliminary investigation then that they have, what's their word again, preponderance evidence that Mohbad was bullied by Sam Larry. They said it there. So it is on them. It is for them to decide to prosecute or not. That's for the DPP because but release investigation to the go evidence to now to they were clear. They'll present it to the DPP. Those ones will review it and we decide that okay, it's fine, I go on. Or no, the link kini, they go on, case he might follow the beacon. So it is left for that. But for civil suit, look okay, maybe for damages to get money for damages and things, yeah, they can do that, but then that comes with its own issues too. It now comes with the issue of legal standing. We call it local standing. Local standing, like who are you? Why will you be the one suing for damages? Yes, only Jomwe. Is he are you his representative? So gbogbo issue here will now come into play. So there are a lot of things, there are a lot of moving parts. Tó lè máa jẹ́ kó lè sue fún irú nǹkan bẹ́ẹ̀ directly. But that's how bóyá rí nìyẹn. Sister Temi ṣe fẹ́ sọ̀rọ̀ nìyẹn, mute you.
Mo ń sọ̀rọ̀ náà ni mo fẹ́ sọ̀rọ̀ ni.
Okay.
Saying, why do we have to pin the death of Mo to those boys? To me, we can pin it to them. Yes. But the only thing is, there are no evidences to back it up. Because according to the wife, she gave that statement. They were bullying him. He has been depressed. He developed BP because of all this bullying here and there. We have videos for that everywhere. Do you understand? So the only thing tí ibẹ̀ yẹn fi ṣe ni pé kò sí evidence láti back it up. Why do we have to know? We can. It's just that because it's everywhere. It's something that is everywhere. Harry Boshembule, his friend was out to tell everybody a story even before kó tó di pó lọ. But the stupid father náà tó yẹ kóun náà sọ àwọn ìtójú ẹ̀ náà ti rí. He's not ready to do that. But either they say ìtójú wọn tiẹ̀ ti rí àti ìtójú wọn ò rí, it's just because there are no further evidences to back it up. And to me, Sam Larry Shima kò lè kọ̀ lọ báyẹn. Even if there's no evidence for NM, Sam will still be punished. Ó kàn lè jẹ́ pé kò pa, but ó bully, and there are evidences for to that one. So if they are not even charging for murder, they'll charge him for bullying him. And second, kini tí mo fẹ́ sọ, before we talk about this, there are no pinning it to the guys. The thing tí mo kọ́ fẹ́ sọ òun ni about Shitu. To me, ó dàbí wá pé Shitu náà act drama. Because to me, I feel like ṣebí Sam ló pè wọ́n náà. And in my head, I be like, ṣé wọn mọ gbogbo kini ni? and the very first time tí mo ti ọkọ gbọ́ kọ́nà fẹ́ wọ́n gbé evidence lọ sí court wọ́n fi hàn nù phone àbí Sanchitu náà wáìnì jù sí ni. These are my own thinking pé ṣebí wọ́n ló sọmọ nù ṣebí ẹ lówó public lówó ẹ máa kówó wá because I don't think àwọn lọ́ọ̀yà tán tí discern gan gbọ́dọ̀ máa ṣe yan bí èwe àbí báwo lẹ máa ń ṣọ́kà bí èwe àbí báwo lẹ máa ń put àwọn ọ̀rọ̀ yìí.
Tí ò bá sí evidence lẹ́ẹ̀kan ṣé
ẹ
wọn
ṣé
lè ní
kò
sọ
wọn
di
mọ̀ pé kò
comedy
sí
ni.
Mr. Python ṣé àwọn ò mọ̀ pé kò sí evidence ńlẹ̀ kan tó máa push fún kán lọ sùn
Bàbá nídìí
lágbájá.
owó sẹ́yìn lẹ́ máa bá maintain
nǹkan tí
àwọn
mò ń
ìyàwó
try
bíi
láti
mẹ́rin
sọ
tó ní ni.
ṣẹ̀ṣẹ̀ lọ bí tí mo fẹ́ lọ nìyẹn pé àbó ṣe ń ṣonípòsí pé kéèyàn kú náà ló ń ṣe àwọn tán lẹ́yàn lẹ́yẹ pé mi ò
Bẹ́ẹ̀
fẹ́
ni
kú o.
àlérógun
so everybody fẹ́ tajà ẹ̀
àlérógun ẹjọ́ ń sọ̀rọ̀ lọ́ọ̀yà.
ló ń sọ̀rọ̀ lọ́ọ̀yà in fact
Kò
lọ́ọ̀yà máa
gbọ́dọ̀
sọ fún
rógun
ẹ pé
ẹjọ́.
ọ̀rọ̀ ẹ yìí kéèsì ẹ yìí ẹjọ́ wà lórí ẹ̀ má wọ́rì a máa ṣe ni bó dẹ̀ ṣe máa jẹ́ nìyẹn gbà tó tiẹ̀ ti mọ̀ pé kò sí nǹkan kan nu ẹjọ́ yẹn wá ní nìṣó ẹ̀ṣẹ̀ sáré ti ṣẹ́gun ò bá pọ̀ lọ́wọ́ wọn yóò sí pẹ̀lẹ́ tiẹ̀ o.
Nígbà tó bá ń sanwó sítìn tó ń sanwó sítìn léraléra tó rẹ̀ sára.
ń bo síasíà Mr. Pythagoras another time kíní yẹn ti fò lọ lórí mi but it's about this me I just think yes it would have been a good thing for Josie to maybe put it in the way of or channeling all his energy that he has towards the bully because I see more light I see more justice on that bullying part. You trying to nail them for why tó ṣe máa nígbà tí kòrò náà tí ì ṣe tán why tó ṣe máa ní pé wọ́n release wọn àbí nǹkan kan I think pé he should have channeled his energy more to that or kí lorúkọ ẹ gbogbo nonsense tó ló ń kọ fún wọn yìí he should have just done that towards that than trying to nail them, trying to tell the DPP pay why would they release them for killing because that my own opinion.
Rere ní Brazil sí. Èyí tí ò yẹ kán ṣe lọ́ṣẹ̀ nǹkan tó yẹ máa ń jẹ mórò náà nìyẹn.
gbogbo ètò ẹ kí Jésù fi lọ́pọ̀lọ́ ó fi ń jápo nínú oko káàkiri.
nǹkan táwọn pípọ̀ yẹn náà ṣe fi hàn pé okay they are free they are killing pay channel this skinny to pay hey they were free now but you guys are and I hope I pray somebody will push for that bullying part somebody will push for it somebody will stand on that on the DPP or Lagos State whatever on their neck to prosecute them for that bullying they have to one need the láti jẹyà yẹn for the death but for that bullying that we have evidence of that we even olóbùkọ ẹ̀ náà dẹ̀ sọ òun sanwó ṣòfò ni kò wá ṣe ṣòfò so there is an acceptance níbẹ̀ yẹn pé you accepted pé even if you are not accepting pé mo bully but there is Mr. Pythagoras kí ló ṣe yín kí ló dé kí ló tẹ dúbẹ̀ yẹn ẹ fi dúbẹ̀ yẹn dídú yìí lẹ́nu jọ mẹ́ta pé ṣe mọ̀ there is acceptance to me there is acceptance níbẹ̀ yẹn pé ṣe mọ̀ mo fún lówó iṣẹ́ ni kò wá ṣiṣẹ́ mi o sọ pé òun but o sọ fún wa pé there is something to link yín papọ̀ sí yẹn so I think my own opinion fún bullying yẹn ó yẹ kó jẹgbẹ́ o ó yẹ kó jẹgbẹ́ kan ó yẹ kó jẹgbẹ́ o wọn ò gbọ́dọ̀ lọ scot free bẹ́ẹ̀ wọn ò gbọ́dọ̀ lọ scot free to the fullest gan ló yẹ kó ṣe fún wọn because they bullied him for years not even months they bullied him for years.
bá dájọ́ ayé ò bá dá dáadáa fún wọn lọ́run á dá fún wọn.
tọrùn á dá fún wọn that's another thing but mi fẹ́ yẹ ká dájọ́ ayé gan dá o mi fẹ́ ká dájọ́ ayé gan dá torí wọ́n ṣe so bad fún bọ̀bọ̀ yẹn wọ́n ṣe very bad olóbùkù vengeance nígbà tó máa sọ̀rọ̀ láàárọ̀ yìí nígbà tó ń búlì Mohbad.
ṣé káàdì wọn ló wá tiẹ̀ gborúkọ sí gbogbo yín lẹ́nu vengeance.
vengeance ọlọ́run ó dẹ̀ ti wá bọ́ mi lẹ́nu vengeance wá sí ọ̀pọ̀ níyàwó rẹ̀ ó ti gbé vengeance sí wa lẹ́nu wípé kí ló kí ni wèrè ẹ tiẹ̀ sọ pé pé bàtà ń búlì Mohbad pé ṣé wọn ò rí ibi tí Mohbad ti ń sáré lóyún tó ti níyẹn wọ́n nà òun o Cynthia náà wà ń bẹ̀ ó lò sí mo ti rẹ́rìn-ín fún ẹ̀rẹ́ olóbùkún Cynthia náà wà ń bẹ̀ tó sọ yẹn ó ti bíìdì pé nítorí Cynthia lọ ṣe é lù àbí Cynthia náà pẹ́ láwọ̀ tó lù alákúrí làwọn pípò yìí and I think pé torí ẹ̀ ṣe rí nǹkan tí ò ṣe dá kéèyàn máa bá kúrí tó nìyẹn I think akúrí wọn wọ́n ti fi kó bá Sanchitu so Sanchitu is now thinking like them now. wọ́n má bínú Sanchitu o n kò fi hàn pé ó dà pé tí òun ní ìyẹn ṣe ronú nìyẹn. Ẹ má bínú tó dáhùn tí mọ́mí fọ yẹn
tí mo fi wúkọ́.
ẹ má bínú tí wọ́n bíbí ìkẹ́ tó dáhùn lẹ́nìkan náà tí mo dẹ̀ fẹ́ ka question ẹni yẹn síta ó dẹ̀ ti lọ ẹ jẹun bóyá mo lè rí àǹtí yẹn béèrè question Kumbi ni wọ́n ní Pythagoras sir if you were Shitu how would you advise Josie towards this case moving forward mo gbàgbé pé mo fẹ́ ka kíní yẹn fún yín ó yá ẹ dá mọ́mí Kumbi lóhùn kẹwàá wá ẹ dá àwọn ọmọ mi wọ́n ní tó bá yẹ pé yín ní sir Shitu.
Bí bá jẹ́ lọ́yà láti advice Josie a sọ pé kó lọ bẹ̀bẹ̀ ni kó lọ bẹ̀bẹ̀ lọ́wọ́
ẹni tó ní kọ́ bá wọn bẹ̀ wọ́n ta ni kó lọ bẹ̀.
lọ fún àdó má bẹ̀bẹ̀ máa ní kó lọ bẹ̀bẹ̀ ni but to be serious if any lawyer tó bá ní interest Josie at heart what they should be telling Joseph Aloba is to go and make peace with his family because in this his vengeful quest for money, for fame, and everything, he has sacrificed a whole lot of people's happiness, their joy, even their life. He sacrificed it on this altar. And he needs some form of penance and some form of remorse and to seek some people's apology. Because legally, there's nothing he can do. So there's no legal advice I can give him. If I'm a lawyer with a good conscience, of course, lawyers who, depending on what they want, can tell him a whole lot of things. But if I ní interest tèmi náà dẹ̀ ní ìbẹ̀rù Ọlọ́run tí mo dẹ̀ tún jẹ́ lawyer, there's no legal advice to give Josie. The only advice is moral one. Àwọn tí ṣe àwọn family ẹ lọ bẹ̀ wọ́n lọ́wọ́ abẹ máa tọrọ àforíjì wọ́n dáríjì tí ọkọ lọ bẹ̀ wọ́n náà. Dẹ̀ máa gbàdúrà k'Ọlọ́run fún ẹ ní peace at the end of your life. Because it's something that's going to haunt you forever. It's something that you're going to remember. Yes, you're living large now. You feel you're okay now. You feel you have some people backing you up. That time will come when it will just be only you till they die. That time where you'll be forced to sit down and reflect on all these your actions. That time where there will be nobody cheering you on, where nobody will be telling you emperor, carpenter, organizer, aloba. Those days will come. You will regret, you'll look for tears, they won't come. And you wish you could turn back the ends of time. But those will just be wishful thinking. And you now wish death should just take you away suddenly. But for somebody like you, that is a bitch. Death is just going to continue doing its own thing, looking around you. They will be moving you from hospital to hospital. You'll be treated from one ailment. You'll be from one ailment to the other. You'll be seeing the shadows of death. You'll be between death and life. You'll be Juggling, you'll be shuffling it. You'll be begging for it. And guess what? You won't even have the energy to even now do some apology yourself. You might even not even have the brain cells anymore to be able to think far back and be able to remember some people that you owe apologies to. And you will be mad at yourself. And while you're still there thinking of how to do it, Olojuade, I don't know what happens in afterlife, but I hope you'll be able to stand tall and face your creator someday.
That is a word of advice from Joseph, but unfortunately, nǹkan tó ṣe ń fún rò nìyẹn pé kò kì í gbọ́ràn. And yesterday, má bínú mọ́ mi kí ni mo máa ka comment since I just quickly want to chip this in pé not yesterday, this morning, and ibi tí Báyọ̀ ti lọ ń sọ̀rọ̀ tó ti lọ ń ṣe kinní, and he was like standing or having the opinion, or should I call it opinion, or affirming pé no, Josie ló máa mú death certificate yẹn fún, Josie ló ní authority. Ẹ gbáriwo yín jàre, Josie ló ní authority láti gba death certificate yẹn. But Mr. Pythagoras, even ká má mú lọ sí legal way, ká má mú lọ sí gbogbo bó ṣe ń lọ, even that word lásán, it shows that these people don't have Josie's best interest at heart. Because if they do, Josie, I'm just saying this, so I'm not advising him. Because Egun àti
Bí mi ẹjọ́ gbà kọ́ ba laminate ẹ̀ kọ́ ba frame ẹ̀ sílé kó máa wò lójú ń bẹ́ẹ̀.
Because how would they be telling you that wàá gba death certificate and you are like yes, that as if it's okay. Egun ló ń gélé lórí. And at the long run of it all, these people will always be with their own family. And I keep saying this thing, Josie, nígbà yẹn, báwo ni gbèsè ayé ẹ̀ ṣe máa rí? I guess Josie doesn't bother. Kò bother Josie, ẹ jẹ́ n bá mọ́mí fọ́ ka message wọn fún yín. And because wọ́n ní Pythagoras, sir, is there any way the Lagos state government can force Josie to bury the boy?
Force? I don't know if they can force you. If he wants to keep the boy till eternity, he can actually do that as long as he has his money to pay for it. Once the Lagos state is done with the body, once they release the body back to the family, it's not their business. As long as their body is not on the body is not on the streets, causing health hazard and things like that, there's really nothing they can do. They'll release the body to them. If they want to continue putting it in the morgue, paying for it, àwọn lọ lówó wọn, wọ́n lè pay for it for the next 200 years. Kò sí nǹkan tíjọba máa ṣe sí. The only people that can compel him for burial will be other family members. Bí wọ́n bá agree pẹ̀lú stance yẹ lẹ́yìn ìgbà tó bá release the body yẹn fún wọn. Táwọn yóò bá wá agree pẹ̀lú stance yẹ lórí ẹ̀, then they can challenge him to the extent of they can now take it to court. Then the court can now decide then. Because tọ́rọ̀ yẹn ò bá dé court cannot decide because sometimes there might not be laws to decide based on. Then the court will have to look at the circumstances surrounding the issue before it. Court lè wá wò ó pé kí bàbá dá dúró kó wọn bẹ́rí ọmọ. Every other family member, ẹ̀gbọ́n àbúrò, màmá, ìyàwó, ẹbí ará, owó sọ pé rọ́ọ̀sì àfẹ́ bẹ́rì. Court can now say, àwọn olólà says lọ ní right sí body. Ṣé right èèyàn kan ju right àwọn márùn-ún àbáwọn mẹ́fà lọ ni? The court can now say, you know what, no, right tí ojú tàwọn people yìí lọ. Since they have all ti pẹnu pọ̀ wọ́n nìkan ní odd person out, you don't have the power to keep that body. They can do as they wish with it. Not the Lagos state government. If anybody really wants him buried, it will be the family members coming together to challenge that man.
Our family member go on, ní liver láti challenge him. They don't have the liver to even challenge him or to tell him or to stand on him. They don't. So our family member, we should just leave that one there. It's just so unfortunate that we feel that way, that, you know what, just bury this boy and let him go. It's so unfortunate. But none of his family member could words, you know, have that liver to stand up against him and said, enough is enough. And sue him, take him to court. Take him to court. Let court, let them intervene. Okay, is there anything else? But unfortunately, we can only say what we can say here. No family member will stand up to Josie and tell Josie, oh yeah, it's time, it's gbogbo rádaràda òṣì tó ń ṣe yìí, ó ti tán. Now, torí ọ̀dẹ̀ báyọ̀, Mr. Pythagoras, ọ̀dẹ̀ ni bọ̀bọ̀ báyọ̀ yẹn. Báyọ̀ sọ pé tó bá lọ bury body yẹn, wọ́n ti close the case yẹn kẹ́yìn, wọ́n máa close the case yẹn, that is the end of the case. Wọn ò ní ṣe case yẹn mọ́. Ń pé tó bá ti lọ bury body, àbí wèrè ni bọ̀bọ̀ yìí ni.
Ẹ̀yin rí pé Báyọ̀ máa ń dà tó lẹ́nu ni.
Ó kọjá ìtọ́ pàápàá, ó kọjá ìtọ́ tí wèrè máa ń dà. Ó kọjá ìtọ́. How can you say that? Ìgbà míì, there are like 10 years tó yẹ kán ti bury body yẹn, tó bá ní new evidence, tó bá rí bí irinṣẹ́ kọ́ rí weapon tó fi ṣe tó fi pa ẹni yẹn, ọkọ ní pòkè trauma bí bọ́dà pé wọ́n rí àmà tó ṣẹ̀ṣẹ̀ fi gbà lórí àbí kíníkan kí ló mú wọn tó máa lọ yọ, tó máa lọ wú egungun, tó máa lọ wú egungun, tó wá tún exam yẹn, tó wá tún exam yẹn ṣe. People just stop. Ọlọ́run, Mr. Pythagoras, nǹkan tó bá kíní ìjẹ́jú nìyẹn. Not about education, it's not about English, it's about these people are senseless. Wọ́n dẹ̀ kọ́yàn ní ọgbọ́n, wọ́n kọ́yàn lọ́gbọ́n. They don't have any ọgbọ́n. They are illiterate ìwé kọ́, they are illiterate for life. They lọ́ máa jẹ́ bẹ́ẹ̀. Nǹkan tó bá kíní ìjẹ́ gangan nìyẹn, Mr. Pythagoras, because people don't understand. Gbogbo nǹkan tẹ́ kà lẹ́nu ìsìn, let them come, let ẹbí wọn lè rìn pé kọ́ wá interpret, kọ́ wá sọ, ẹ máa gbọ́ rádaràda òṣì tó máa sọ. Nǹkan tó bá wa débi táwa yìí ní nítorí pé àwọn illiterate òfò yàtọ̀ sáwọn ṣàgálà míì ti ẹ̀bú àwọn yẹn, because èèyàn ti mọ̀ wọ́n, téèyàn bá kọ̀ tún bú wọn yẹn waste time. But there are some people that feel.
Ọjọ́ bí mi at the end of the day, ṣé tálámà wá fọ́ọ̀tì nítorí èmi wò pé bóyá Ọlọ́run ni ò fún ọlọ́pọlọ pé àbí báwo, kí lẹ́yìn fi.
Ọlọ́run ẹ ṣé bàbá mi, ẹ pẹ́ fún wa, àgbà yín àdálẹ́. Ọlọ́run kọ́ ni fún wọn, wọ́n yóò lórí burúkú ni. Àwọn yóò ṣìtọ́ bí wọn náà. Ṣẹ́rí, we were talking about this thing níjọ́ Sunday and mo dẹ̀ ní mi ò really ráyè láti participate náà. This thing, àwọn parents mi gan ni ọ, yes, àmọ́ pọ́lọ̀ ló ń bá yàn tọmọ. But ṣẹ́rí, ilé tó bá ti dín pé parents tí ọmọ ẹ bá ti mú ₦1 wá fún ẹ, tó ti wá sọ di olórí ilé, tó yẹ pé ìwọ ìyá gan ò ní lè sọ̀rọ̀, ó máa hùn ẹni. Then ọmọ yẹn ti lọ, that child is gone. That child is gone. I can't mark off one example from my own. My mom, see, over 60. Pẹ̀lú bí ìyá ẹ̀ lówó, òun náà lówó tiẹ̀, but láíláí wọn ò bí kú. Ó yí bẹ̀rù, yẹ over 60 kò dẹ̀ ń ṣe pé bóyá because of anything. Sometimes the way you train your child, your children, it matters a lot.
Bóyá táwọn ìyá wọn náà bá lọ́pọlọ ló fẹ́ fi tọ́mọ.
Àwọn ṣẹ́rí láyé ìgbà yẹn wọ́n lọ́pọlọ, olóògùn púpọ̀ ni wọ́n ní. Ṣẹ́rí àwọn tó ń bọ̀ látàyè ìgbà yẹn, nígbà tó dáyé ìsìn tí ìjẹkújẹ ti báyé wọn jẹ́, tí wọn ò lè sọ̀rọ̀, tí wọn ò lè sọ pé ọmọ pé owó tó ní ló máa dìmú sí. Èmi ìnìyẹn nǹkan tí mo bá sọ ló máa ṣe sẹ́. Nǹkan tí mo bá sọ fún ẹ bó ṣe máa jẹ́ nìyẹn. So that's just part of it. In fact, fact tí n bá wo ní society tàti bára wa ń gbà mí àwọn pé ẹjọ́ nítorí ọ̀nà truly ṣé àwọn people yìí ṣé inú ilé ayé kan náà lájọ wà ní. Some people are just dumb. Tó bá ní pé àwọn èèyàn kọ́ dumb, it's not about money, Mr. Pythagoras. Ọ̀tọ̀ lówó, ọ̀tọ̀ ní common sense. They don't just have that common sense. They don't.
They are all poor upstairs. They are poor.
Ẹ wá wo bí káwé àwọn míì tún bàjẹ́ dé Mr. Pythagoras. Wọ́n gbóyìnbó. Òyìnbó wọn ò correct. Àwọn gangan ló máa múra kankan bí olójú kan ṣe náwó. Àwọn ló máa sọ fáwọn ká Cambridge. Àwọn ló máa ṣe bẹ́ẹ̀ ni pé ó ti opinion àwọn matter. Ibi tá ti dára wa nínú kíní. Mr. Pythagoras, it's about understanding. It's about common sense. Òun la fi bára. If people have common sense, this thing ṣe bó òun láyé padà sọ ní pé there is nothing that can be done to Naira Marley and Sam Larry for the death, but for the bullying, yes. Àti gbé gbogbo yẹn sílẹ̀, àwọn yẹn náà wọ́n gallivant kiri. The justice is to bring the nurse. Kí nọ́ọ̀sì wá jìyàn wẹ̀. Yes, unfortunately, mistake ìṣẹ̀lẹ̀ lọ́wọ́ ẹ̀. Wàhálà kọ́lọ̀ ń dáríjì mi. That is what we but àwọn wèrè yìí àwọn ogun lọ́rùn ni. Ó tì wọ́n jù down the stairs ni. Kó tó lọ ọmọ mi lù pa ni.
Bébì mi da èmi fẹ́ lọ sùn.